Here we go.
How's it going?
David, good. How are you?
I'm good. It's been a morning.
I think we're on. We got a lot of participants who are already on here,
Okay.
um, and counting. So we'll go ahead and get started. We've been doing this really lunch and learn
Yep.
webinar. We did it a couple months ago with cryptocurrency, and now we're doing this with. I'm so excited about estate planning. And to have David White here as well, someone I've known for quite some time, a great man, first of all, and then definitely knowledgeable. And so, David, I'm just going to get right to it. One of the reasons why I wanted to have you on to for this type of discussion, you hear everything in the news about people passing away. Like for me, I thought about Prince. You know, you hear about Prince, and he's got all these people around him, but he doesn't have a will. And and then you couple that with now all the laws are changing all the time. You have the baby boomers are older, and so now there's a transition of wealth. There are a lot of questions. You know, what do I do? How do I take care of my aging parents? How do I make sure my kids are going to be provided for if something happens to me?
Hmm.
These are all the questions that we're getting. So, and so, David, I want you to go ahead. If you would just um, start with the presentation, and then I want to definitely save a few minutes for questions and so you can answer a few questions. I know we're going to get some in the chat.
Perfect. So, hello. My name's David White. I'm an estate planning attorney here at Simpson Law Firm. Today, we're just going to talk about some of the things that you need to think about when coming up with your estate plan, whether you are in your 20s just starting out, or you are in your 80s thinking about how you're going to protect your children down the line, how you're going to protect grandchildren, all of those things. Like I said, my David White. Glenn just mentioned it. The baby boomer generation is aging, and we're going to see the largest wealth transfer in the history of the world. What does that mean? How do you protect your assets as they go to the next generation? If you're planning to inherit from a parent, how do you make sure that you take those assets and do what's best for you so that you're not facing a federal estate tax down the road? Again, the average inheritance is going to be approximately $72,000. That's a pretty hefty chunk of change that we need to consider where that goes. Glenn will help you out making sure you get that invested, but we want to make sure that is taken care of for future generations, not just your generation. So a lot of people think I have an estate plan. I went online, I got a will, good to go. Or I have a trust, we're good to go. Well, we're going to talk about some of the pitfalls of that. Did you get your will online, or do you need to come see an attorney? Because online, you're only going to get a cookie cutter plan that is right for most people. It doesn't take everything into account. Is it outdated? Did you move from out of state into a new state? And maybe we need to update the law, we need to update some things. Beneficiaries have fallen out of favor, etc. The last is your trust funded if you have one? And we'll talk about that a little later. But today is a little bit of a difficult day for me. My kids' daycare is closed, so it's been crazy. But they are the reason that I do this. They're the reason that I want to make sure I have an estate plan in place in case something were to happen to me. One, my children are minors, so making sure that I have been guardians listed in all of my documents to take care of them. But two, just making sure that the assets that I'm going to pass to them are protected for their lifetimes.
What I'd like to add is any questions you have as David goes through this pretty quickly, put them in the chat just like last time. Put them in the chat, and then we'll have time at the end to go through those. Thank you.
So what we're going to talk today about is what is an estate plan. Most people think an estate plan is just a will or a trust, but it involves so many other things, and we'll talk about those key components, plus just how to keep your family out of as much conflict as possible. You'd be surprised what people fight over after death that we need to consider. So most estate plans, and what we are going to do if you come see us at Simpson Law Firm is we're going to first start with your powers of attorney. Everybody needs a durable power of attorney, a healthcare power of attorney, and a living will. Next, we're going to talk about the testamentary document. That's going to be either a will or a will and a trust. So, what if you don't have an estate plan? What if right now you're sitting there and you say, I don't need one, I don't have one, everything will just go to my spouse? Well, if you don't have a plan, I promise you, whatever state you live in has a plan for you, and it may not be the plan that you like. In South Carolina, if you died intestate, meaning without a will, half of your assets would go to your spouse and half would go to your kids. In North Carolina, one third to your spouse and two-thirds to your kids. Most people do not want that. They would like everything to pass to their spouse, and then after their spouse's death, for the assets to then flow to their children. So, in order to avoid this, you need to write down what you want so the state doesn't decide how your assets flow. Then, when we talk about wills, we're talking about probate. Generally, when people talk about probate, they're talking about two things: the probate process, which is just the process to pass your assets, going into court, telling the court what the decedent owned, then the court approving a distribution to the beneficiaries, paying off debts, paying off funeral expenses, all of those things. And then any assets that are subject to probate fees, which you pay to the state. And probate is a costly, it's timely, it's a pain. I'll tell you that some of my best estate planning clients are people who went through the estate administration and probate process, and they said, I don't want my family and loved ones to have to go through that because it takes a long time. Assets are held up, they can't be distributed out, and ultimately they're subject to a judge's final decision. We estimate that all in probate will cost your estate between 2 and 7% of the value of the assets going through probate. That's going to include, like I said, the fees you pay to the state, attorney's fees, executor's fees, any appraisals that a court requires for, say, a house or anything like that, filing fees, any extra court costs. So between 2 and 7%, think about what you think your assets are valued at. Take the low end of 2%, and that's minimum what I think you're going to pay in probate. So here again is, let's just say you have a house worth $500,000, a retirement that's worth 300,000, and a life insurance worth 500,000. If all of that goes through probate, it's going to cost the estate between $26,000 and $91,000 to pass those assets. Plus, it's going to take your children's time or whoever the beneficiaries are. You're going to have to look at uh, minimizing capital gains, estate tax minimization, all of those kind of things. So, how do we avoid probate? Well, let's start here. Sorry. So, like I said, your estate plan is going to include a durable power of attorney, a healthcare power of attorney, a living will, a last will and testament, and potentially a revocable or irrevocable trust. Your durable power of attorney is your financial power of attorney. This is going to give an agent the authority to make decisions for you, to sign on your behalf in regards to all aspects of your life that are financially related. So sign on bank accounts, sign on life insurance, pay premiums for insurance, all of those things. There are generally two ways to set up a durable power of attorney. It can be effective immediately, meaning as soon as you sign it, your agent has authority to sign on your behalf, or it can be what's called springing, which means it's only effective upon your incapacity. The problem with springing powers of attorney is they oftentimes require two physicians to declare you incapacitated, and doctors don't love taking on that liability. So I always recommend you make it an immediate, durable power of attorney so that if something happens to you, your agent can step right in and there's no delay in paying the bills, taking care of the house, all of the important things in your life. Next, we have the healthcare power of attorney. So, your healthcare power of attorney is going to allow your agent to make medical decisions on your behalf when you can't. If you are, if you have capacity and you're conscious and you can communicate with doctors, they're going to do exactly what you want them to do. Your healthcare agent has no authority to override your decisions regarding your healthcare. However, if you're in a coma, if you're under anesthesia and doctors can't wake you up to get your answers, that's when your healthcare agent would step in and make those medical decisions for you.
Hey, Dave, we got a quick question.
Yeah.
Who might someone choose to to be their power of attorney? What
Mm.
typical people or family members or whoever are you seeing for those?
Usually, to begin with, people always choose their spouse to begin with. If something were to happen with the spouse, then we move on to perhaps older children who are trusted, particularly with the financial power of attorney. You want to make sure that your agent is trustworthy to handle your assets and to be able to access the bank accounts. Your healthcare power of attorney, people choose people who share their values in terms of what they want to have happen in their medical care. Or if you have a family member who's a nurse, a doctor, something along those lines, people often choose those people to make the healthcare decisions. The agent can be the same, but it doesn't have to be. And in reality, if you have two separate agents, they are almost a check on each other because your healthcare agent will make those medical decisions, and ultimately, your durable power of attorney is the one who will pay for all the healthcare decisions that are made. So they kind of check each other that way. The final document is a living will. So the living will is just for end of life situations. In North Carolina, the living will takes over if you have an incurable or irreversible condition that doctors think will lead to death in a relatively short period of time. Think of end stages of cancer. If you are in a persistent vegetative state and you're never expected to regain consciousness, aka if you're brain dead or something along those lines, or if you have advanced stages of dementia or some other cognitive decline where you're not expected to regain that cognition, the living will steps in and says, please remove all life prolonging care and just allow me to have a natural death. The living will and the DNR are slightly different. The DNR, which you would sign with a medical professional, that it has to do with life saving care. The living will only takes effect after that life-saving care. You are stable. Doctors just think there's nothing more we can do to save you at that point. And then we have your will. So your will is going to set forth all of your wishes regarding who's going to receive your assets. In most states, if you have minor children, who would you like to appoint as a guardian of those children until they reach the age of 18? It's going to ensure that your assets are passed not according to the state, but according to your wishes. If you have a child who you no longer speak to and you don't want to leave anything, you can do that in a will. The state would just give it to them uh, through the intestate succession. The things that a will won't do. I get this question a lot. A will is not going to avoid probate. Anything that goes through your will goes through probate because the will has to be probated through the probate court. It does not provide for your incapacity. It doesn't name temporary guardians, which is another thing we do for people with minor children. Is to name somebody who can take the kids until permanent guardianship is awarded. Let's say you have minor children and you want to name a sibling as their guardian, and that sibling lives out of state. We want you to name a temporary guardian who lives nearby, who the police can call, who social services can call to take those kids until your sibling can get down, get into court, and be awarded permanent guardianship. It's not going to avoid any state estate taxes. Right now, there's no state estate tax in North or South Carolina, but other states you'd have to check with an attorney there. It cannot override certain legal agreements. For this, we're mainly talking about beneficiary designations. So, on your bank accounts, investment accounts, life insurance, retirement, if you have a beneficiary designated, those assets are going to pass outside of probate immediately upon your death. The will cannot override those. Those are essentially a contract with that financial institution to pay the assets to who you name and not your estate. So, how do we avoid probate? Put it in a trust. So, a trust is going to be similar to a will, it's just an entity that exists during your lifetime. The trust will have the same terms in terms of who your beneficiaries are, how you want to distribute the asset, what the split of the assets are going to be, but it avoids the probate court because it's not in your individual name at your death. So, we talked earlier about is your trust funded? If you have a trust, is it funded? We like to think of the trust as this red wagon. You want all your toys in the trust, so in the red wagon. If you do that, you're going to avoid probate. If you don't put your assets in the trust, you don't put everything in that red wagon, when the successor trustee comes along, there's nothing there, and all of those assets are still going to go through probate. It's a sad fact that a lot of people create trust, they think they're protected, and then they forget to actually name the trust as a beneficiary or retitle assets in the name of the trust, and then you've paid a lot of money for a trust that is not going to avoid probate, which is your wish. So, what can a trust do? They can, there are a lot of blended families out there. Let's say that upon the death of one spouse, he wants his assets to go to his children, wife wants her assets to go to her children. We can do that in a trust where we leave everything to spouse, but then after spouse's death, we split it up. It avoids probate, as we talked about. It's going to protect assets from minor children. If you leave assets to a minor child through your will, they're going to have to create what's called a uniform transfer to minors account. That money goes into that account. The court's going to appoint a custodian of that account, and the minor is going to receive the money at 18 by operation of law. A lot of people don't want an 18-year-old to just get a lump sum of money. I think we all know what some of us were doing at 18 and getting a large chunk of money. I would have had a really nice car, probably not much else.
Hey,
Uh,
hey David, there are a lot of people who don't want their 40-year-old children with the money because they aren't proved they haven't made wise decisions.
yep.
And they also protect their assets. That way, even though their children are adults.
Yes. So you can keep money in trust for as long as you wish. You can keep it until for the life of your child and then ensure that it passes to grandchildren. You can say, well, I don't know, let's say 60 years old, they get the payment. Whatever age you choose to distribute the assets outright is completely up to you. It can also be used to preserve assets for, let's say, a disabled child in a special needs trust, which would protect their assets so that it's not counted against them if they need to qualify for government assistance like Medicaid. Um, so, great question there. So, what kind of trust do you need? Most people, if you are below the federal estate tax level of 13.99 million per individual, you're going to want a revocable trust. A revocable trust is going to be treated as you during your lifetime. You will be the trustee, you will be the beneficiary, you can do whatever you want with the asset. There are some times where particularly people may need to qualify for Medicaid or they're above that federal estate tax level, and we look at irrevocable trust planning. Irrevocable trust planning sometimes becomes niche with the online community, and they think that everybody needs an irrevocable trust. What you need to know about an irrevocable trust is you lose all authority over your assets. If you put a house in an irrevocable trust, you no longer control whether that house is sold, how much it's sold for, what happens to the proceeds. The trustee does. And you cannot be trustee, or it's no longer an irrevocable trust. Uh, Asset protection trust is just another form of an irrevocable trust. When we, there are two ways we can create asset protection trusts. You can create them for a spouse, or if you create a trust for children through your revocable trust, we can then protect those assets from their creditors, such as debtors, marital claims, all the above. A lot of people are concerned because they may not like their son in law or daughter in law, and they say, I don't want them to get anything. Well, the keeping funds in trust would definitely keep it away from them, but also the law presumes that if your child were to predecease you, a son or daughter in law does not inherit those funds just because your child is no longer alive. We spoke about special needs trust. Q-tip marital trust is generally for can be used for those blended families where, let's say, husband and wife each have kids from a separate marriage. After one of their deaths, their property goes into a Q-tip, which essentially pays out income to their spouse. Uh, all the income of the trust pays out to their spouse. Their spouse can reach the principal of the trust if they need to, but their assets are locked down and become irrevocable. Then, after the death of the spouse, that's when they'd be distributed off to the children of the first decedent spouse, and whatever happened to the surviving spouse's children, their assets would go there. So let's talk about some myths that people have. If you become incapacitated, you have a will, so you'll be fine. No, you need those powers of attorney. Your will only takes effect after your death. Your powers of attorney take effect while you are still living. So it is very important that you have those powers of attorney so that somebody can make decisions for you and not have to petition the court for guardianship or something like that. I'm good. I bought a will online. Again, you get what you pay for. Those online companies, they are good. They're going to give you a cookie cutter plan. For some people, that works. For most people, it doesn't take into account your specific situation. Everybody has something a little different in their family, whether that is a stepchild, whether that is a person that you consider a child, although you've gone through no formal adoption proceedings, those kind of things. And we talked about what will happen if you leave minor children or grandchildren assets. They will just receive those assets at 18 through a uniform transfer to minor's account, which may or may not be what you wish to have happen.
So if it's let me ask you one question. I know you're going through this, but
Mhm,
what if it's a single mother?
mhm.
There's no spouse in the picture and no parents. Who would you recommend to leave their insurance, retirement proceeds if the children are still of minor age?
So there are a couple of options in that situation. Obviously, it's always best if you can. I don't say always, but most of the time, best, most cost effective if you have a trusted family member or friend who you can name as a trustee. But there are also trust companies out there. For instance, our law firm does offer the potential of acting as a successor trustee to hold assets for however long you need them held for your children or grandchildren. Most banks and trust companies will act as trustee. Obviously, once you go down that route, they come with fees. But if there's no one else, that is a great option to have essentially a third party. Or if you have children that you know will fight each other, to have a neutral third party who doesn't know the history of the kids, isn't an aunt or an uncle who's going to have to hear from them every day about distributions. Sometimes having that neutral third party is nice because we can say yes or no and not have to deal with the repercussions of, well, they're not being fair and they're giving my sister more of this than she deserves or that kind of thing. So we'll talk a little bit about the gift and estate tax. As I stated earlier, right now in 2025, the gift and estate tax exclusion amount is 13.99 million per individual. So just under 28 million for a married couple. In 2026, after the signing of the one big beautiful bill, that amount's not going to sunset. It's going to go up to 15 million per individual. So 30 million per married couple, still indexed for inflation. So every year it's going to keep rising. We'll see usually somewhere around November, mid December, they'll come out with what that amount will be for the next year. If you are over that exclusion amount, everything above that is going to be subject to a 40% estate tax. That's not a great outcome if you have 29 million and now 1 million is subject to 40%. So 400,000 is going to the federal government.
Yeah, and that's if you're married, right?
Yeah.
For that
Mm-hmm.
amount, right?
Yeah.
Okay.
We can also talk about some annual gifting, which can get funds out of your estate without having to use any of your gift and estate tax exclusion amount. So each year you are allowed to give a certain amount to any person, as many people as you wish. For 2025, it's 19,000. It's going to stay at 19,000 in 2026. I'm not sure why it's staying for 2026. It's generally gone up by 1,000 for the last few years, so we'll see in 2027 what happens. But essentially, you can give, let's say you have three children, you can give them $19,000 each and not have to file a gift tax return and not have to use any of your gift and estate tax exclusion amount. So some people wonder what's the best time to transfer assets? Let's say you need to qualify for Medicaid, or I've had people who say, do I really need a trust? Can't I just give my house to my children right now and avoid probate? You can. The problem then becomes capital gains tax. So, what's a capital asset? almost everything you own is a capital asset. It either has capital gains or capital losses. Most most of the time we're talking about a house with capital gains or investments, stocks, those kind of things. So anytime a capital asset is sold, it is subject to capital gains tax for the difference between your purchase price, also called your basis, and the sale price. There's a difference between long term and short term capital gains. So, long term capital gain is going to be any asset that you hold for 1 year or longer. So, over 1 year, sorry. On day 366, it becomes a long term capital gain. And below, you'll see the long term capital gains tax rates. For the vast majority of people, it's going to be 15%. For those high net worth and ultra high net worth people, you may reach the 20% level. If it is held for 365 days or fewer, it is a short term capital gain. And at that point, it is taxed at your income tax level. So, whatever your income tax bracket is, that's what the difference is going to be taxed at. Now, let's say you transfer right now, you give your house to your children. They take that house at your basis, meaning the purchase price what you paid for it plus any improvements you've made. If instead you were to leave your house to your children through a will or a trust, they get what's called a step up in basis, meaning that on the date of your death, they take that house at whatever the then current market price is. So if they sell the house the next day for that market price, they don't pay any capital gains. I have it.
That's a powerful strategy, and I think hopefully you're gonna talk about that because this is big.
Mm-hmm.
Okay, I'll be quiet again.
Oh no, you're fine. So let's consider a house right now that you purchased for $500,000 and you did $20,000 in improvements. Your basis in that house is $520,000. Today, your house is worth $820,000. So you have $300,000 in capital gains. If you, let's say you're married, you and your spouse decide to sell that house, you're fine because it's your primary residence. Each of you get $250,000 in capital gains exclusion. You don't pay any capital gains. But let's say that today you decide to gift your house to your children because you don't want to go through probate and you think that'll be easier. Well, now your children take the house at your basis of $520,000. If you were to pass away tomorrow, they sell the house for $820,000. It was not their primary residence, so they do not get that $250,000 in capital gains exclusion. It's a short term capital gain because they didn't hold the house for longer than a year. So they're going to pay whatever their income tax bracket is for most people, probably 22 or 24% of that $300,000 gain. Now, let's say instead you leave your house to your child through a will or a trust. Your child's basis is $820,000, the then current market value. Again, if they turn around and sell it the next day, they have zero capital gains. They don't owe any capital gains taxes. So you could avoid a lot by just leaving a house in a trust or a will. And there are some strategies we have if you need to qualify for Medicaid, such as irrevocable trust, that will still allow the house to be included in your estate, meaning that it would get a step up in basis after your death, but still, like I said, get that step up and avoid the capital gains tax for your children. Everybody has someone or something they want to protect. Let's come in and see us. We're going to get you the right plan to make sure that your kids are taken care of, grandkids, brothers, sisters, nieces, nephews, whoever you want to leave assets to, charities if you're charitably inclined, so that they stay out of court, they avoid the headache of probate, and they avoid all the conflict. Here's our contact information. So my email is david@simpsonestatelaw.com, or you can email our general email at info@simpsonestatelaw.com. And here is our phone number. Anybody have any
Yeah.
questions?
No, we got a ton of questions. So
Okay.
so so thank you for
Mhm.
going through that presentation. That was incredible. And I definitely wanna hit a few topics. Um, let's start with let's go back. So one of the first questions that we have was that what happens if someone has dementia, but they don't have a living will in place?
Mhm.
What happens and what can they do?
So
Or
there are
what
two
can you do
situations.
if it's a family member?
Yeah. If you have a family member with dementia and they have a healthcare power of attorney but not a living will,
Mhm.
um, ultimately the healthcare power of attorney would make all medical decisions, including end of life decisions. If there's not a healthcare power of attorney, at that point, a family member or somebody is going to have to petition a court of relevant jurisdiction to be named a healthcare proxy in order to be able to make those decisions. Usually, it's the court is going to go based off of the kinship. So a spouse would be first in line, children would be next. If they're no spouse, no children, it would be parents, then brothers and sisters, all that kind of thing down the line. So
Okay.
that's why it's really important to have your healthcare power of attorney and living will so that that situation doesn't occur. Your wishes are laid out immediately known.
Okay. No, thank you for answering that. Um, and so we have people who are here from multiple states around the country. And is it true that every state has different laws when it as it pertains to estate planning?
Yes, every state is slightly different. Most states have adopted some form of what's called the Uniform Trust Code and the Uniform Probate Code. But every state has slightly different variations of what's required for a will to be valid, a trust to be valid. Uh, Almost every state has statutory language on durable powers of attorney, healthcare powers of attorney, and living wills. So it's very important to seek out an attorney who is licensed in whatever jurisdiction you're in. Um, to go forward on that point a little bit, a lot of
Mhm.
people I see have moved from out of state and they just presume that their trust is no longer valid or their will is no longer valid. And to that, I say your estate planning documents are valid in all 50 states, no matter where you live. There may be other reasons that we want to change and update the law. For example, those powers of attorney, I think you should always update to whatever state you are in, just because, especially with the healthcare power of attorney, if you take an out of state healthcare power of attorney to the hospital, they're going to turn around and give it to their lawyers who are going to have to make sure that it was validly executed in the other state. And that's just time when most of the time you don't have a lot of time. Doctors need a decision made.
Mhm. Okay, that's a great answer. Um, you talked about capital assets, and that's a huge part. I see how unfortunately money is squandered. So
Mm-hmm.
you have multiple, let's say the client has multiple assets. You have your home, you may have some individual stocks and bonds, then you have your retirement account. And I've seen people in the past use the other two, the home and maybe the stocks, sell those, live off of those, and then pass the retirement to their children. And
Mm-hmm.
all of that money's taxed, right? They have to pay an ordinary income tax when the children receive that money.
Mm-hmm.
Um, can you speak little bit more about having, for one, two things. One, you talked about Medicaid. um, to protect assets. If you have a parent that may have, you know, declining health and they need to
Mhm.
protect their assets, what things can they do? And then two, just the power of those capital assets. Again, just the step up in basis.
Mhm.
If you could just speak to that a little bit more.
Mhm. So I would say that to begin with, obviously the power of the capital asset is the step up to be able to sell, especially stocks and investments, sell them at the market price and not have to pay any capital gains, or keep them in that stock for another 10 years. And now you've limited the amount of capital gains that you're actually going to have to pay instead of starting. I think we had a client one time, especially for a house. We had a client whose great grandparents had bought a house on Lake Norman for nothing years ago.
Hmm.
And every successive generation gifted the house to their children before death. And now our client owned a house that was worth something like $3 million, and probably two and a half of that was capital gains. So she was going to have 2.5 million in capital gains tax to pay. When if you just pass it on, you'll avoid that. As far as the power of retirement accounts, so retirement accounts are beasts of their own, and you want to make sure you stay on the right side of the IRS in that sense. We often see people who will leave a retirement account to a trust. At that point, we want to ensure that the trust has the correct verbiage in it so that the trustee can hold the account in that tax deferred account. They'll have to continue to receive the RMDs for the 5 or 10 years, depending on the actuarial tables and whatever the IRS says. Um,
But you're talking about required minimum distributions if somebody's over the age of 73.
Yeah.
Yeah,
hmm
got it.
They'd pay income tax on that, but they'd avoid a 10% tax on early withdrawal of that account if there was an early withdrawal to a beneficiary. So, all of those things are important to discuss with an attorney to talk about what's the best way to do this to avoid my children or my estate paying more in taxes to the state than they need to.
Right. Yeah. So a couple more questions that we have here. And anybody else that has them, please send them on. Um, One would be, I think we may have answered that one. But if a person is in medical decline, when is the best time to start trying to establish an estate plan, or is it too late at that point?
It's not too late. There is a very different definition of capacity to sign estate planning documents. So, legal capacity for estate planning documents is just knowing what your assets are, who you're passing them to, and that you want to do that. It can get into a gray area when you're in a mental decline. So, for instance, there are a lot of people who have early dementia, and they're great in the morning and they start to lose it in the afternoon. We want to see them in the morning. As long as they have capacity at the time that they sign it, we're good to go. But the earlier you can get in, the better. It's so much better if there's no decline and we're just in there from the jump so that we can get it done easily.
Okay. Um, yeah. Can a trust be changed once it's created?
A revocable trust, yes. All day, any day. You can change it every day of your life until the date of your death. Easy. An irrevocable trust, to a certain extent, we can put in some terms that allow us to change some administrative provisions. We cannot change the beneficial provisions once that trust is created. So that's another downfall of an irrevocable trust. If you name a beneficiary and then have a falling out with that beneficiary, we can't remove them. They still have to remain a beneficiary. With a revocable trust, like I said, you have the right to amend, revoke, change it in any way that you choose at any time during your life.
Okay. Couple more here. Um, let's see. So this is a good one. If I die before my spouse, can they change my trust? Also, uh, can they take my kids out of it? So
Uh,
especially when you're dealing with a second, a third spouse.
so, in most cases, when we do a joint revocable trust, yes, we keep it revocable up until the point that the surviving spouse passes away. In some blended family situations where they want to ensure that assets are passed to their children, at that point we can create like what I talked about with a marital Q-tip trust where the assets are held in trust and irrevocable trust at that point is just a piece of the larger trust. It's irrevocable, held for the benefit of the surviving spouse, and then passed on to the children of the first decedent spouse. That can be done, and that cannot be changed by the surviving spouse. So in general, yes, surviving spouse can change the trust, can remove any beneficiaries they choose, but we can add provisions that prevent it at least in respect to the first decedent spouse's assets.
Okay. We're gonna two more questions here. You got a ton of them, man. You're hot. Let's see. So, do you, and I don't know what this is. Hopefully you do. Do you recommend the Ladybird deed? I think is what it's
Yeah.
trying to say.
So, Ladybird deed in North Carolina is also called an enhanced life estate deed. And
Okay.
actually, North Carolina has now said that they are that the Ladybird deed. For a while, we weren't sure if Medicaid could use the house for repayment. Now, North Carolina has made it clear that they can't if a Ladybird deed is used. I'd say, yeah, it's a good option. I think there are a couple of good options. It just depends on what your situation is. For instance, sometimes we use what's called a divided interest deed, where we deed 1% of the house to a child or multiple children. They hold it with rights of survivorship. So after the death of both spouses, they automatically receive it outside of probate. That would also avoid Medicaid repayment. So I'd just say talk to us. We'll talk about the benefits and detriments of each.
So let's talk about the well, my final question. Let's talk about the cost and effect. So to set up a will, just give me a range of what that might cost for just the average will, and then
Yeah.
the average revocable living trust. What might something like that cost?
So for our plans, the will plan, which includes those powers of attorney, starts at 1995. Depending on add-ons, it could get up to, I'd say, 29.95. So
Just the
$1,000
more
give or
assets you
take.
have,
Yeah.
yeah, the more
Uh,
complicated your estate, the more it'll cost.
the trust plan starts with, like I said, the will, all the POAs, and a deed to your house. That starts at 49.95. Again, you add on some things, it could get up there. The trust gives us a better foundation to add on to things, so it could get a little higher. But if you take the base of 1995 to 49.95, I understand that's a $3,000 difference. I tell people if you go through probate, not you, but your estate is gonna pay over $3,000. I would estimate.
So, so it sounds like if you have an estate, let's say your net worth is, let's say 1 million, and there are people who have on this who are listening who far over that. So if you're $1 million, if it goes through probate and everything is probatable, then now you're talking anywhere from 20 to $70,000 in potential fees that you might pay versus getting this done earlier and having the peace of mind for 5,000 or
Exactly.
so. Okay,
Yep.
got it. Yep. So no, it makes a lot of sense. And then the more money you have, the
Yeah.
bigger that delta is. So no,
The
that
more it grows and
well, this makes
well
sense. This is not an exciting topic for most people, and but it is so important. We all are born to die at some point.
hmm
And I believe in being a great steward over what God has blessed you with. This is a part of the puzzle. And getting an expert like yourself makes all the difference. Um, I've recommended you many, many times and will continue to do so. And everyone who I sing your way sings your praises. So David, just thank you for your time. And
Thank you for having me.
we're gonna send out this information as well. You can reach out to David White, Attorney White, if you'd like to speak with him, and you'll also be able to, if you guys can't sleep at night, you can go back and rewatch this video on all the trust and Q-tips and all that great stuff. But thank you everybody for joining, and thank you too, David. Have a great rest of your day.
Thank you.